Hello everyone. Today I am updating you on the Letecia Stauch case. Please subscribe and hit the notification bell and we'll get to it. First off, I checked the jail roster and Letecia is not appearing on it, so I'm assuming that she is now in Pueblo undergoing her competency evaluation. Next, I'm going to go over a summary of all the papers that were made public yesterday in the case. The first things to go over are that there were P12 was to the El Paso County Criminal Justice Center, P13 was to the Widefield School District 3, P14 was to Academy School District 20, P15 was to Fort Carson Police Provost Marshal Division, P16 was to the Horry County School District, P17 was to Fort Carson Police Provost Marshal Division, addressed to a different person than who P15 was addressed to. And then the scope of the subpoenas was that for document P12 to the El Paso County Criminal Justice Center, it says, produce any and all medical or mental health records relating to Letecia Stauch, to include but not be limited to kites, notes, treatment records, testing records, raw data, progress notes, daily logs of all treatment providers and staff. P13 is to Widefield School District 3, P14 is to Academy District 20, and P16 to Horry County School District, and they are all requesting any and all records relating to Letecia Stauch. P15 and 17 to Fort Carson says any and all records relating to Letecia Stauch, to include but not be limited to notes, treatment records, testing records, raw data, progress notes, daily logs of all treatment providers and staff. P11 is People's Motion for Consumptive Testing. And basically what this one is saying is that there are some evidence samples that have not been tested yet at the labs. The samples were taken from Gannon's room, and the samples that they're talking about in this motion are 6 swabs that contain possible blood taken from the bedroom walls, from droplets on the bedroom walls, and 4 possible blood swabs from the baseboard and window in Gannon's room, also from unidentified droplets. And it says that only DNA and not serology will be run because the samples are too small to run both. The prosecution wants to test 1 swab from each wall, leaving 2 swabs from each wall available to the defense for testing. As I said, the swab samples are from droplets on the bedroom wall, and they state that also portions of the bedroom wall were taken into evidence, and swabs could be taken from them by the defense if the defense is wanting to do independent lab testing. And then of the other 4 swabs, 3 were from the baseboard and 1 from the window. The prosecution wants to test 2 swabs from the baseboard. And once again, testing would be for DNA only because the samples are not big enough to do serology as well. That would leave 1 baseboard swab for the defense, but they also say that the entire baseboard has been taken into evidence, so if the defense wanted to do independent testing, they could access that baseboard. And then it goes on to state that the purpose for the DNA testing is to see if there is genetic material that matches the DNA profiles of any of the involved parties, including Letecia and Gannon. Then we get to P10, which is the People's Notice of Receipt of Potentially Protected Information through the Criminal Justice Center records. And basically it says that it's giving the defense notice that the prosecution received documents that contain potentially protected information regarding Letecia from El Paso County Criminal Justice. And then P10A is a statement by the person who received the records and how they obtained those records. And P10B is information on how the evidence is being safeguarded at this point. And then we get to the response documents. P8 is a response by the defense. They're filing an objection to a motion that was filed on June 23rd by the prosecution, where they were requesting all past mental health documentation from the defense. P9 is a response to prosecution's motion on June 23rd, wanting to waive confidentiality and privilege and disclose all of Letecia's medical and social history records. The objection to P8 was on the grounds that the request was overbroad and violates attorney-client privilege and HIPAA. The objection to P9 is that it was overbroad, violates privilege and HIPAA and constitutional rights. And then we get to some more responses. P16 is a motion to quash the subpoena to Horry County School District. P15 is the defense response motion to quash the subpoena from Fort Carson. P14 is quash the subpoena from Academy School District 20. P13 is a request to quash the subpoena to Whitefield School District. P12 is a motion to quash the subpoena to El Paso County Criminal Justice Center. And then we'll go to the reasons. For all the motions to the school districts, it states that the subpoenas were overbroad, unreasonable, oppressive, and do not meet warrant requirements. The motions to quash the subpoenas to Fort Carson give the reason that the subpoena is overbroad, oppressive, unreasonable, and violates state and federal law and warrant requirements. And then we'll talk about response P12, which was to quash the subpoena to El Paso County Criminal Justice Center. And the grounds were that it was overbroad, oppressive, unreasonable, and violates state and federal law and warrant requirements. And then it goes on, of course, to describe events, including that on June 29th, the prosecution sent a subpoena to the Criminal Justice Center custodian of records, who was Amanda Zamora. And then Amanda Zamora delivered private, confidential, and privileged medical and mental health records directly to the district attorney's office in violation of state and federal laws. There was no written permission from Letecia, and we'll talk about that in a moment, because it goes to a few laws that I am familiar with. I'm not an attorney. I should explain that right now, but there is privilege and confidentiality in both the medical and mental health professional fields, and there are codes of ethics. To the very heart of the provider and client relationship is confidentiality. And in the mental health field, getting a subpoena is a nightmare. It's not something you want to have happen. And when it does, you need to hope that the defense, of course, files objections. You don't want to damage the reputation of the profession, and you have a duty to your client. And unless there's a compelling reason that can be backed up by law for you to disclose, you should not disclose. So then we get to the competency question. The prosecution jumped the gun because competency has not been ruled on. She hasn't had the evaluation yet. So at this point in time, she would need to give permission for her records to be disclosed. If she's incompetent, then she's not capable of giving consent, and then someone needs to be placed in a guardianship position, whether that's the courts or a person, and then they can give permission. Also, that would give a more direct purpose for subpoenaing records, which a therapist could comply with, in that it goes to confirming the status of competency. Previous records aren't really pertinent to her competency at this point in time, and this is not about her state of mind at the time of the crimes that she's charged with. That would be something else entirely different than whether or not she's competent to stand trial. And we'll just have to see what happens with the competency hearing, because it could all be moot at that point, because if she is incompetent, she won't be going on trial anytime soon. And if she is competent, they'll be moving on to the next phase. And if the defense tries to bring up an insanity defense, then that opens the door for those previous mental health records. Thank you for watching Another Day in the Car with JuleZ. I look forward to hearing from you in the comments or via private messages. Please subscribe and hit the notification bell, and I will see you next time. Thanks for watching. Subpoenas for protect in North Carolina, or was it South Carolina? In the Carolinas. P17